This is my lawyer's motion to stay sentence, which was written while I was in jail. Travis Hines was sentenced to time in jail and a fine after being convicted at a bench trial on one count of misdemeanor resisting an arrest in violation of LARS 14108. Travis Hines is currently serving jail time on that same sentence. Travis Hines wishes to have the entirety of his criminal case reviewed by a higher court from the beginning to the end, including all pretrial hearings, trial and post-trial hearings. Undersigned counsel is aware of State v. Malone and wishes to make the record abundantly clear that Travis Hines is requesting appellate review before completion of his sentence, including jail time and payment of any fine. He explicitly objects to his sentence, including jail time and payment of any fine. A defendant's notice of intent to apply for a writ of review, request for return dates, and request for an extension of a return date was filed by undersigned counsel on 4/25/2022. Undersigned counsel received an email from Natchitoches City Court on 4/26/2022 indicating that the defendant's notice of intent would not be signed until later. See Exhibit A. Because Travis Hines was sentenced on 4/11/2022 and the default time period for filing an application for a writ of review is 30 days from the date of sentencing, Travis Hines is running against a deadline of 5/11/2022 to file his application for a writ of review, absent an extension of time on the default return date period, as requested by defense counsel. In the interim, the defendant's notice of intent that was filed on 4/25/2022 requests an order that the Natchitoches City Clerk of Courts provide transcripts and copies of all pretrial hearings and motions, trial proceedings, and post-trial hearings and motions, along with copies of any admitted evidence at all such proceedings. This information has not been provided and must be provided to ensure adequate and competent preparation for an application for a writ of review by undersigned counsel. Without access to this requested documentation, due process is jeopardized and undersigned counsel is put into a precarious position in trying to preserve his client's desire for review in light of this timing issue. Undersigned counsel is filing this pleading into the record and requesting a stay of execution of the remainder of Travis Hines' sentence. Travis Hines protests and objects to any contrary ruling by the Natchitoches City Court in compliance with the requirements articulated in State v. Malone. Travis Hines is adamant about having his case thoroughly reviewed by a higher court because he was deprived of his constitutional rights and unlawfully arrested. Undersigned counsel has obtained court minutes from the Natchitoches City Courts involving recent plea and sentencing decisions by Judge Owsley, and these decisions show that in multiple cases the accused received no jail time, even for domestic battery charges that were dropped down to disturbing the peace pleas. See attached Exhibit B. Benjamin Cloyd, the same prosecutor in this case, was also involved in many of the cases in Exhibit B. Travis never even hit a librarian, or anyone for that matter, nor committed any offense comparable to such egregious actions in many of the cases in Exhibit B. To be sure, many of the defendants in Exhibit B likely hit individuals and battered them and still received no jail time. Travis merely refused to provide his name because he believed that officers did not have a lawful detention nor a lawful arrest. Travis is not asking for reconsideration of sentence in this case because he does not want to waive his right to request a writ of review of his conviction by rendering review mute. He simply highlights these sentencing disparities in support of his request to have his current sentencing at least stayed in the hope that this court will extend the same degree of leniency to him that it did to many of the battery defendants in Exhibit B. If higher courts uphold his conviction, Travis Hines will subject himself to serving the remainder of his sentence. Travis Hines does not present any flight risk in this case. He made all necessary court appearances and appeared for trial in this case. He has no prior convictions. He is an honorably discharged military police officer. Travis has no other pending charges against him. Travis has never harmed nor threatened anyone in connection with this case. He has not been charged with stalking, improper telephone communication, or any other comparable offense arising from this case. No evidence has been introduced against him showing that he directed or caused anyone to threaten anyone else, despite references to such alleged conduct by the trial judge in the sentencing in this case. The trial court's beliefs conveyed at the sentencing hearing about Travis directing anyone to make threats is not supported by any sound and competent evidence in the record of the sentencing hearing. Nor in the record of any other proceedings in Travis Hines' case. What other individuals in the public do is not the responsibility of Travis, when he has never encouraged anyone to engage in unlawful conduct. In light of all the foregoing reasons, undersigned counsel requests a stay in execution of Travis Hines' sentence while awaiting a resolution of the post-trial motions filed and a resolution of an eventual application for a writ of review. Certificate of service to certify that a copy of the proceedings has been hand-delivered to opposing counsel of record. All right. Order on motion to stay sentence. Judge Owsley has signed an order considering the foregoing motion. It is ordered that a hearing be set for May 2nd, at which the prosecutor for the city of Natchitoches appear and show cause why the relief requested in this motion should or should not be granted. All right, and Shanita has attached the following signed motions. Motion for post-verdict bail pursuant to Louisiana Code of Criminal Procedure, Article 312. Motion to enroll. Defendant's motion for a new trial and defendant's motion for a post-verdict judgment of acquittal. This judge will not address the defendant's notice of intent to apply for a writ of review, request for a return date, and request for an extension of return date until May 3rd, which is the date he set for the motions listed above. All right. Okay. All right. And minutes of court. Domestic abuse battery. Defendant present without counsel. The state is represented by Assistant DA Clyde Benjamin. The defendant is charged with domestic abuse battery strangulation. The state amended the charge of domestic abuse battery by strangulation to the charge of disturbing the peace. Defendant changed plea to guilty to the charge of disturbing the peace. The sentence of the court was fine and cost of $421. Default of that payment, 30 days in jail, 30 days in jail suspended, 6 months unsupervised probation. Next one, State v. Angela Domino, disturbing the peace. Defendant present without counsel. The state is represented by Assistant D.A. Clyde Benjamin, Jr. The defendant is charged with domestic abuse battery with strangulation. The state amended the charge of domestic abuse battery to the charge of disturbing the peace. The defendant changed plea to guilty to the charge of disturbing the peace. The sentence of the court was fine and cost of $406. Default of that payment, 10 days in jail, 10 days in jail suspended, 30 days unsupervised probation. Next one, State v. Bryan. Theft, simple assault, disturbing the peace, remaining on premises. Defendant present without counsel. The state is represented by Assistant D.A. Clyde Benjamin. Defendant's charged with all those. The state dismissed the charges of simple assault and remaining on premises. Defendant changed plea to guilty to the charges of theft and disturbing the peace. The sentence of the court was 90 days in jail. Credit for time served. Approved by Judge Owsley for all of these. State of Louisiana versus Roderick Waddle. Let's see. Simple assault. Defendant present without counsel. All of these are present without counsel. The state is represented by Assistant DA Cloyd Benjamin. The defendant is charged with simple assault. The state amended the charge of simple assault to the charge of expired inspection sticker. The defendant changed plea to guilty to the charge of expired inspection sticker. The sentence of the court was a fine and cost $266. Default of that payment, 10 days in jail, 10 days in jail suspended, 30 days unsupervised probation. Robert Owsley. States versus William Squires. Driving while intoxicated, no brakes or turn signal. Defendant present without counsel. The state is represented by Assistant DA Cloyd Benjamin Jr. The defendant is charged with driving while intoxicated first, no brake lights, turn signal. Defendant changed plea to guilty to the charge of driving while intoxicated first. The state dismissed the charge of no brakes, lights, turn signal. The sentence of the court was the following. Driving while intoxicated first, fine and cost totaling $977. Default of payment, 30 days in jail, 30 days in jail suspended, 6 months unsupervised probation. Alright, State versus Shantwayne Lewis. Expired inspection sticker. Defendant present without counsel. The state represented by DA Cloyd Benjamin. The defendant is charged with disturbing the peace. The state amended the charge of disturbing the peace to the charge of expired inspection sticker. The defendant changed plea to guilty and sentence of the court was fine and cost of $266. Default of that payment. 5 days in jail, 5 days in jail suspended, 30 days unsupervised probation. Wait. Okay. Oh, wait. I don't... Fred S. Gahagan, City Court Judge. So, he sits in for Owsley. State of Louisiana versus Robin Jackson, D. Theft. Defendant present without counsel. The state is represented by Assistant DA Cloyd Benjamin. The defendant is charged with theft. Defendant changed plea to guilty and sentence of the court was fine and cost of $496. Default of that payment, 30 days in jail. 30 days in jail suspended. 6 months unsupervised probation. And that's Owsley again. State of Louisiana versus Tresman Brown. Battery on a dating partner. Defendant present without counsel. The state is represented by Assistant DA Cloyd Benjamin Jr. The defendant is charged with battery on a dating partner. The state amended the charge of battery on a dating partner to the charge of disturbing the peace. The defendant changed plea to guilty to the amended charge of disturbing the peace. The sentence of the court was fine and cost totaling $406. Default of payment, 10 days in jail, 10 days in jail suspended, 30 days unsupervised probation. Okay, I think that's it, actually. Nope. State of Louisiana versus Paul Bordelon. Driving while intoxicated, obedience to traffic device, open container. Defendant present without counsel. The state is represented by Assistant DA Cloyd Benjamin. The defendant is charged with The defendant changed plea to guilty to the charge of driving while intoxicated. The state dismissed the charges of obedience to a traffic device and open container. The sentence of the court was the following. Driving while intoxicated. Fine and cost totaling $977. Default of payment, 30 days in jail, 30 days suspended, 30 days unsupervised probation. With Robert Owsley. State of Louisiana versus Charles Kelly. Domestic abuse battery. Defendant present without counsel. The state is represented by Assistant DA Cloyd Benjamin. Defendant's charged domestic abuse battery. The state amended the charge of domestic abuse battery to the charge of disturbing the peace. Defendant changed plea to guilty to the charge of disturbing the peace. The sentence of the court was a fine and cost of $406. Default of that payment, 10 days in jail, 10 days in jail suspended, 30 days unsupervised probation. State of Louisiana versus Chantel Collins. Resisting an officer, domestic abuse, battery, child endangerment, false imprisonment, disturbing the peace, intoxication. Defendant present without counsel. The state is represented by Assistant DA Clyde Benjamin. The defendant changed plea to guilty to the charge of resisting an officer and false imprisonment. The state dismissed the charges of domestic abuse, battered child endangerment, and disturbing the peace intoxication. The sentence of the court was the following. Resisting an officer, fine and costs totaling $411, default of payment, 10 days in jail, 10 days in jail suspended, 30 days unsupervised probation. False imprisonment, fine and costs totaling $421, default of payment, 30 days in jail, 30 days in jail suspended, 6 months unsupervised probation. Approved by Robert Owsley. Now that's it. All right.